What will the lawyers ask? Clearly defining the agency relationships in a real estate transaction is important for both the clients and the brokers, salespersons. Broker. Brokers must be clear about who they represent in a transaction to determine what duties are owed to which party. Agency relationships become extremely important if a dispute arises. The first question that a lawyer will likely ask a broker when a claim is filed is, "Who did you represent?" Agency relationship between the broker and client. Agency is a relationship in which one person, the agent, is authorized to represent the interests of another, the client, in business dealings with third parties. By the early 1900s, the Arizona courts recognized the agency relationship between the broker and client in a real estate transaction. By 1950, the Arizona courts overwhelmingly held that a real estate broker is an agent with fiduciary duties to their client. An agent has fiduciary duties to the client, such as confidentiality, accounting, reasonable care, loyalty, obedience, advocacy, and disclosure, creating an agency relationship. An agency relationship is created by consent. An agency relationship may be created by express consent, or it may be implied by the conduct of the parties. No formal agreement is necessary. A broker simply must agree to represent the interests of the client, who consents to the representation and delegates authority to the broker to act on the client's behalf. Compensation does not establish an agency relationship. Arizona courts have consistently recognized that a broker may represent one party in a transaction but be paid by the other. Agency duties. Many states have enacted agency legislation that attempts to specifically list a broker's duties to a client and non-client. Arizona has enacted no such legislation. However, the Arizona Department of Real Estate Commissioners rules do address a broker's duties, so it is important to become familiar with AAC R4 28-1101. The Arizona Association of Realtors, AAR, Real Estate Agency. Disclosure and Election, READ 1022 form, is designed to assist brokers in defining and establishing agency relationships. Additionally, the use of this form will prevent undisclosed dual agency. The READ form is not an employment agreement, but a disclosure and election of the agency relationship that a buyer or seller will have with the broker in the transaction. As the READ form makes clear, regardless of whom the broker represents in the transaction, the broker will exercise reasonable skill and care in the performance of the broker's duties. Further, the broker is obligated to be honest and truthful to both parties and disclose all known facts that materially and adversely affect the consideration to be paid by any party. Additionally, the stigmatized property notice is included in the READ form to alert buyers that information regarding certain stigmatized property is not required to be disclosed. The READ form explains the fiduciary duties a broker owes when representing a buyer or seller exclusively, such as loyalty, obedience, disclosure, confidentiality, and accounting. The form also notifies the buyer or seller that the broker may represent others interested in buying or selling the same or similar properties. The READ form introduces the concept of dual agency, limited representation. The form discloses that, in the case of dual agency, there will be conflicts, and that disclosure of confidential information will be made only with written authorization. Dual agency, limited representation. Dual agency, limited representation, occurs when one broker individually, or two salespeople within the same brokerage firm, represent both the buyer and the seller in a real estate transaction. Dual agency is lawful with prior written consent. The AR consent to limited representation 1202 form should be used to obtain the consent of the parties in a dual agency situation. This form explains dual agency to the buyer and the seller prior to obtaining the parties' consent to the relationship. In general, a dual agent must do the following: exercise reasonable skill and care in the performance of the agent's duties. Deal honestly with both buyer and seller. Disclose in writing to both buyer and seller. O. Any information that the seller is or may be unable to perform. O. Any information that the buyer is or may be unable to perform. O. Any material defect existing in the property being transferred. And O. The possible existence of a lien or encumbrance on the property being transferred. See R4 28-1101b. In general, a dual agent must not do the following: advocate or negotiate on behalf of either the buyer or the seller. Disclose any confidential information that would place one party at an advantage over the other party without the informed consent of the other party, such as, O. The buyer is willing to pay more than the price offered. O. The seller is willing to accept less than the listing price. O. A party will agree to financing terms other than those offered. O. The repairs or improvements that a seller is willing to make or that the buyer is willing to forego. And or O. The confidential motivating factors of either party. Termination of an agency relationship. After termination of an agency relationship, the fiduciary duty is ended. However, confidential information must remain confidential after the termination of the relationship. NAR Code of Ethics, Standard of Practice. 1 Tucker 9 imposes a similar obligation to preserve confidential information provided by clients in the course of an agency relationship after the relationship is terminated. Confidential information should not be revealed, used to the disadvantage of the client, or used to the advantage of the realtor or other third parties. How does agency terminate? Here are some reasons that agency would terminate. Remember that confidentiality never ends. Say one of the principals dies, what happens? Well, there are many scenarios depending on how many principals are in escrow. Say the owner of a listing dies, what happens to the sale? If the deceased seller was the exclusive principal of the residence, probate is necessary unless the owner implemented financial planning measures to circumvent it. In such cases, the court will designate a personal representative empowered to execute closing documents and finalize the property sale on behalf of the estate. The buyers may want to cancel. Say the seller died in the home, it would have to be negotiated that the sale is canceled. How about if a party to the contract becomes mentally incompetent, or has dementia, or other reasons? How about if the seller files for bankruptcy? The sale would be up to the bankruptcy court. Say there is an act of God, a storm hits the house, a fire, vandalism, and it is more than 10% of the price to fix the damage. The contract could be canceled. Say that the agent is not been ethical and is doing things illegally. Of course, the contract could be taken over by another agent via the broker. However, that agency from the illegal agent would be terminated. When the close of escrow happens successfully, the agency relationship ends. Except for confidentiality. Say you took a listing and it expires, your agency relationship is terminated. Except for confidentiality. What if the government takes the property through an eminent domain? End of agency. If your broker loses their license, your agency is terminated until you find another brokerage and restart the listing or sale. Say both parties to the contract agree mutually and cancel the contract, your job is over unless you are still working with the buyer or seller. Sticky business in some cases where an attorney may have to take over or probate court. Understand that when your agency ends, your client is on their own. Who did you represent? In the event of a dispute or claim, who a broker represented will establish the broker's duties and ultimately the broker's liability. For example, in Aranki vs. RKP Investments, 194 Arizemder 206, 979 P2D 534, Appers 1999. The court recognized the important distinctions between the claims by a buyer against a listing agent, where no fiduciary duty is owed, and by a buyer against the buyer's agent, where a fiduciary duty is owed. In a 2015 real estate malpractice lawsuit, the court quoted the law as set forth in the Aranki case when discussing a broker's duty to the client versus a broker's duty to a non-client. See The Buyer's Questions, Real Estate Tales from the Courtroom. And to read about a case involving the duties of a dual agent, see The Sex Offender Next Door, Real estate tales from the courtroom. That is why the first question that a lawyer will likely ask a broker when a claim is filed is, "Who did you represent?" 1. Michelle Lind, Esquier, is an attorney who currently serves of counsel to the Arizona Realtors R. She is also the author of the book, Arizona Real Estate, A Professional's Guide to Law and Practice, 3rd ed. Watch for the 4th edition, which should be available soon. For more real estate-related articles, visit Michelle's blog at Arizona Real Estate, A Professional's Guide to Law and Practice. Arizona Real Estate Professional Guide, blogspot.com. This article is of a general nature and may not be updated or revised for accuracy as statutory or case law changes following the date of first publication. Further, this article reflects only the opinion of the author, is not intended as definitive legal advice, and you should not act upon it without seeking independent legal counsel. 9.523. True agency relationships include fiduciary duties. Remember these duties as you are responsible for all of them. To help you remember them, think of OLD CAR. O. Obedience. Unless the action is illegal that the principal is asking, the agent must obey all legal instructions in a prompt and efficient manner. L. Loyalty. The agent must have the best interest of the principal above even their own interests. D. Disclosure. The agent must disclose all pertinent information to the principal. C. Confidentiality. Unless it is unlawful to do so, the agent must protect and keep confidential information just that. A. Accounting. The agent is obligated to account for any answers regarding the property or money the principal entrusted to the agent. R. Reasonable care. The agent only performs services for which they have expertise. They are also required to meet the standards of skill, care, and diligence in all of their transactions.